All right, everyone. Shh. Welcome back. Welcome back. Hope everybody had a nice weekend. Thank you for giving my parents such a nice show last week. They had a lot of fun. They enjoyed their stay. We had some fun this weekend. Let's see. How's everyone doing today? Good? So anyone have any questions for me today? Anyone? Any thoughts? Did anyone see what happened last night?
Yeah.
What happened last night? Ah, see, I told you, okay? You are on the cutting edge. You are learning about this for anyone else, okay? So last night at 10 p.m., when I was preparing for class, the judge in Brownsville issued a preliminary injunction enjoining DAPA, the Deferred Action Program. So the very program we were talking about 2 weeks ago, whether it was constitutional or not, a federal judge less than 12 hours ago put on hold nationwide. This is front page of the New York Times. It's a huge deal. What's interesting for your purposes is they didn't reach the constitutional issue. So there's a principle in Supreme Court case law that says when there's a way to resolve a case narrowly, we do so narrowly. When we can avoid resolving something in constitutional grounds, we avoid invalidating a law on constitutional grounds. That's precisely what Judge Hainan did last night. So you haven't studied administrative law, but the long and short of it is that usually when the government makes certain types of rules, they have to submit through a process called notice and comment, which requires the public to send notices and comments, and there's like a 90-day review period. It's a fairly cumbersome process, which makes sure that people have a stake in what administrative law says. The president did not follow these rules, and the Judge Hainan said, as a result, this policy is void. This is not the end of the issue. As we speak, some DOJ lawyers in Washington are braving the snow to get their papers ready. This case will probably appeal to the Fifth Circuit in the next 24 to 48 hours. The Fifth Circuit's a federal court of appeals in Louisiana, New Orleans. If I had to guess, this will have to be resolved by the Fifth Circuit in the next month or so, because this is a fast case. And as I think I mentioned 2 weeks ago, the Supreme Court will take this case before the end of June. There's no way it can't. They really can't avoid it. So we'll be talking about this case much more. But you guys are on the cutting edge. You knew about this before anyone else. No one was paying attention to it last night until I got the email at like 10:15 saying, order granted. So it was a pretty significant stay. In terms of the separation of powers, this is probably one of those wide-ranging federal court injunctions since Youngstown itself, because you have a federal court judge telling the president and all of his subordinates, don't do this, nationwide, everywhere. So whereas Homeland Security was ready to start accepting applicants for this deferred action program on the 18th, tomorrow, right? That is all now on hold. So this is a very big constitutional issue. This will race up the Supreme Court, and I promise you I will keep you apprised of it as the semester goes along. But this is really, really exciting and fascinating times. All right, any questions on that? Yes, sir.
Where do we find the court's opinion?
If you go to my blog, joshblackman.com, I wrote a post on it last night at like 1 in the morning. So I'm warning you that the decision's 123 pages, which I read last night. I was not planning on being up that late last night, but I was. So I have to teach you about it, of course. So yeah, it's a 123-page opinion. It's really thorough. You may agree with it or not, but this is not some sort of slapdash, whatever, political, whatever. This is a serious legal opinion that even critics are now having some time thinking, wait a minute, how do I respond to that? So the judge took his time with it, and he issued a 123-page opinion, which is very, very significant. But yeah, I encourage you to read it, and I put a summary. I'm sorry? Hainan, H-A-N-E-N. He's a federal judge in Brownsville. Yes, ma'am.
With the injunction, it was just for the DAPA memorandum, right? Not DACA?
Okay, so let's be precise. So DACA, Deferred Action for Childhood Arrivals. This is a 2012 program, which allowed dreamers who are effectively people brought here to this country without authorization to get this deferred action, right? That program is in place. But in November, the president said two things. I'm going to grant this to the parents of citizens, and I'm going to expand DACA. In other words, DACA was previously capped at people under the age of 30. The Dreamers were under the age of 30. The president eliminated that cap. So now new people who would have signed up for DACA as Dreamers cannot sign up. So DACA is in place, but the expansion of DACA is put on hold, as is DAPA as a whole.
So the people who got there and were permits in 2012, they're good?
Yeah, I mean, the DACA from 2012, that was not challenged. That remains in place. The only thing that affects is going forward, people who would apply for new. Although what wasn't stated is if, and this is the part which people don't fully appreciate, if DAPA is void, then so is DACA. They stand or fall together. DACA wasn't challenged, so it wasn't before the court, but it would be quite conceivable for a state to challenge DACA now. But I think that's an open question going forward. Any other questions? Yes, ma'am.
I can't find it on your blog.
If you go to joshblackman.com, it's like the third post down. If you scroll down, it was an instant analysis of the decision from last night. You'll see it. I wrote like 3 things on it already. It was a long night. Okay. Any other questions? All right. Appreciate your interest. This is a really interesting topic. All right. So so we go back now to federal power. We shift from the president not executing the law, perhaps, to Congress executing too many laws. In our last class, we began our discussion of the Commerce Clause, right up here. And we discussed that the Congress has the power to regulate commerce among the states. And what do these 3 words mean? Regulate, commerce, and among. We saw in Chief Justice Marshall's decision in 1824 in Gibbons versus Ogden. This was the case where New York said that steamboats from New Jersey couldn't dock in New York waters. Right? That case didn't involve a federal law. It involved New York attempting to block commerce coming from New Jersey. And what did the Chief Justice say? He said, that is a violation of the Commerce Clause because only Congress can regulate commerce between the states. But you'll recall Marshall didn't only say you have to have physically a boat going between one state and another. He said it's possible that commerce, or intercourse as he defined it, within one state is sufficient to trigger interstate commerce. Okay? That left open a lot of questions. If you can have commerce in one state be interstate commerce, how far does Congress's power stretch over regulation? So we discussed a number of cases last week, right? Where the court tried to figure out different tests. So some tests look to saying, well, you know, commerce is trade, but manufacturing isn't. Other cases said, well, if there's a direct effect in commerce, Congress can regulate it. But if it's an indirect effect, Congress can't. And what you're seeing in all of the different cases leading up to 1936 was the Supreme Court trying to adapt its case law to this evolving industrial society. But then everything changed in 1936, as we discussed. This was, as we said, during the time of President Roosevelt's term. And at the time, the Supreme Court had invalidated a number of his programs. In response, President Roosevelt considered packing the court, appointing one new justice for all the justices over the age of 70. This would have had the direct result of giving him a virtual majority in every single case. And we discussed why this was a tough decision. And ultimately, the 5-4 decisions against the president started going the other way. The 5-4 decision starting to uphold the president's power. Okay? But rather than just upholding various aspects of the president's economic regulations, the court began a path of widening the scope of the Commerce Clause. First, concerning economic regulations during the New Deal, but 30 years later, those precedents were expanded to cover the civil rights laws. So we're in this interesting place where commerce power was expanded to target economic regulations, which has a relationship to commerce, And then later, decades later, they were used to promote the Civil Rights Act and prevent discrimination in places of public accommodation. Okay? So I want you to keep in mind, and in your notes, you can just keep a running list of something of an arc of how these cases progress. How during the 1800s and early 1900s, you had the Supreme Court grappling with this new industry, this new economy, trying to figure out how do we fit the strictures of our Constitution to this new industry. And then after Roosevelt threatened to pack the court said, not our business. We're going to defer to whatever the Congress says. And these policies were amplified during the Civil Rights era. But then, as we'll discuss later today, we get to the 1990s, where miraculously the Supreme Court said, wait a minute. We've gone far enough, guys. No further. Let's put the brakes on this. Let's identify some limits on the powers of the Congress under the Commerce Clause. So what we'll see today is a complete spectrum, from Wickard to Hearts of Atlanta to Lopez. These cases represent an entire arc of our Commerce Clause jurisprudence, which is why I teach them all in a single unit. Okay, any questions on that overview? Any questions on that? Okay. All right, so let's get started. And let's talk about Wickard v. Filburn for a second. This is a really interesting case, which I love the facts of. So this is a farmer Roscoe Filburn. He had a farm in, I think it was Montgomery County, Ohio. Okay, let's see. Let's go back up top. Rob, what did Farmer Filburn do that wasn't allowed?
He sowed 23 acres and harvested 239 bushels.
So he was a farmer and he grew wheat, right? What was the problem with that? Why was that a problem?
Congress was trying to regulate interstate commerce because there was a surplus of wheat.
Okay, good.
Problem.
Okay, good. So Congress enacted something called the Agricultural Adjustment Act, right? What is this Agricultural Adjustment Act? Congress said, you know what? There's a problem. We have too much food. There's too much food. We have all these surpluses of food, and this is causing prices to drop. If you find the problem, stop me, right? So because the prices of crops are dropping, farmers aren't making enough money, and they may not grow enough stuff. So Congress has this idea. How do we fix this problem? I got an idea. Let's limit the amount of crops farmers can grow. And if they grow too much crops, they grow too much wheat, we'll tax it. We'll fine them. So here you have Roscoe Filburn sitting there with his the grains of wheat falling through his fingers. I love this picture. And then you have the ominous, the Claude Wickard, who is the Secretary of the Agriculture. This is an awesome picture of him. You can see with all these new dealers, these charts and these projections of what the ideal amount of eggs and rice and wheat is, and he knows, right? So the way this law worked is the Secretary of Agriculture in his smoke-filled room in Washington would set the national quota of this is how much wheat we should produce. And then each state would get a different percentage of that. Okay? If you produced more wheat than your quota was allowed, they would fine you. Okay? I think his fine was about $117. So if you can imagine if you're a poor farmer trying to make a living and feed your family, and you say, I got an idea, let me try and work harder and plant some more crops, and the government fines you. Welcome to the New Deal. So whether or not these policies make economic sense, we can debate about that later, right? But this was the judgment of Congress to give the Secretary this power to decide how much wheat should be grown. Filburn said, I don't care, I'm going to do it anyway, right? So Austin, what was Filburn's argument about why he didn't need to comply with this law, why he can grow as much wheat as he wanted?
He was saying that he grew the excess in order to feed his family, so it wasn't going to affect interstate commerce. He grew up for like personal consumption.
Exactly. Okay, so here is Filburn's argument, right? The wheat he grew on his farm wasn't intended for sale. It wasn't intended to be shipped to another state. It wasn't even intended to leave his farm. The wheat that he grew was for him, his family, and his livestock, right? He wanted to feed his family and his livestock. Everyone see the issue? This was never meant, okay? Hugh, what did the government argue? Why did the government say that this was something that the federal government could regulate?
I think they were talking about that him by himself, if only he did it, he would be okay, but it would actually, everybody else did it, would have a substantial effect.
Okay, good. We'll get to substantial effects in a moment, right? That's exactly right. But did the government, Luke, did the government seem to care that he was never shipping the wheat? Did that seem to bother the government?
No.
Why not?
I think it has something to do with cattle, does it not?
Had to do with what?
Him feeding his cattle and cattle being put into stream commerce.
Okay, well, not exactly.
So they were only trying to regulate the market.
Marketing, exactly. Okay, so the government was trying to be cute here, right? They're saying, listen, you don't have to actually ship this. We're merely regulating the fact that you're marketing this wheat. And how is he marketing it? By having it, right? Yeah, exactly. The mere fact that he has it is marketing. He's signaling to the world, look, I have all this wheat. Look how nice it is, right? Whether or not he actually sells it, the government says, is sufficient for interstate commerce. Okay? So, Lauren, if this case had been brought to the court before 1936, right, before Roosevelt came to power, how do you think the court would resolve this issue? This case was brought before 1936.
I think that they would have, I mean, the necessary and proper, it would have fallen in Congress's power.
Well, let's take this simple. Was the wheat, this local wheat, right? Was that interstate commerce? Why not? Under the court's previous case before 1936, why would that not have been interstate commerce?
Because it doesn't have any movement. It would have just stayed local.
Okay, that's one answer. I think that's right. Okay, there's a couple reasons why. So before 1936, and pay attention to this, I think she's right. This wheat never traveled. But even more so, the courts held that things like manufacturing and agriculture are not commerce. Commerce is the trade or exchange of ideas or goods, whatever, right? This is before 36. Don't make, this is not your final answer, right? Okay, but now Plowman, after 36, we have the case of Darby, we have the case of Jones and Locke and Steele. What did the court hold in those cases? How did this analysis change after 1936? What was holding in Darby? Lauren, what was Darby? We did the last case we did on class on Thursday. Was it a manufacturing case?
Yes, and then it was overturned.
What overturned?
That the manufacturing was not part of interstate commerce. They said that it was.
Yes. Right. Okay. Darby, this is a class we did on Thursday, rejected all these pre-1936 cases. They said manufacturing is commerce. It doesn't matter whether the goods made in this factory will leave the state. The mere act of manufacturing affects interstate commerce, right? Okay. So we see in 36 and 37 there's a shift in the court's precedents. But even then, right? Manufacturing, creating goods that may cross state lines at some point, I think we can all see that there's some connection to interstate commerce. But Wickard was different, right? Michael, why is Wickard different than the manufacturing of different goods and products?
Well, it expands commerce.
How so?
Well, by saying that other words, it says that Congress can regulate any act of interstate commerce. I mean, it just broadens the definition.
What's different between the wheat in this case and what's being manufactured in other cases? What's the key difference?
Personal consumption.
Yes. Okay, and this is the important distinction. When you're building something through manufacturing, maybe it will cross state lines, maybe it won't, who knows, right? Maybe you use machinery that came from out of state. There are a lot of different connections with interstate commerce when you're manufacturing goods. But here, the wheat was entirely local. The seeds came from Ohio, right? The soil was in Ohio. The fertilizer came from his cows, right? Everything was local. There was no prospect of these grains of wheat ever leaving state lines. So this is for myself and my family. Now, this wasn't actually true. So the actual facts of the case was he was selling this wheat, but we can ignore that for a moment. He actually was selling the wheat. I love the facts of constitutional cases because they're always wrong. He actually was selling the wheat on the down low. But we'll pretend that didn't happen just for a moment because the Supreme Court said we'll pretend he's local wheat. All right, so here we have what the Supreme Court would later call the most wide-reaching exercise of commerce plus power ever, right? So Sarah, how does the court explain why this local wheat is interstate commerce? It gives a couple rationales.
I guess there are no problems with people selling it. And then,
Well, that's the problem Congress is trying to address. My argument is, how does Congress have the power to regulate this? Where does it get the authority? What's the argument there? Okay, I'm glad that's wrong. I'm glad you said that, right? The court does not say that Congress can regulate intrastate. By the way, everyone knows the difference between interstate and intrastate. Intra means within one state. Inter means between two states. Make sure you know the difference. So the court doesn't say that Congress can regulate purely interstate activity, right, Sarah? What does the court say?
just that they have the power to regulate supply.
No? I'm not right with that.
Yeah, I think their argument was that even if there is no interstate commerce, the fact that the farmer is growing that wheat and consuming it, even if it's just for himself, that still has an effect on interstate commerce.
What kind of effect? What's the key word I'm looking for? Substantial effect. That's a test from this case, right? The test from Wickard is, does this activity have a, quote, substantial effect on interstate commerce? Substantial effect.
They say they talk about like homegrown wheat and the sense of
Ah, good. So that's the second part of the court's analysis. I'll get to in a second. That's exactly right. Okay. So the first part of the court's analysis is if some sort of activity has a substantial effect on interstate commerce, Congress can regulate it. Okay. So the question becomes, how big is substantial? Right? It's not just any effect. It can't have some sort of insignificant effect. It has to be substantial. And that's the question Sarah answered, right? How, Demi, how big of an effect does Mr. Filburn's local wheat have on the interstate market? Just Mr. Filburn.
Well, it's not going to have a large effect at all, but one thing they talked about at the very end is that it was unfair to the other wheat growers, and so if you apply one standard to him, then you have to apply to everyone else.
Okay, that's exactly right. Mr. Filburn, standing by himself with his bushels of wheat in his barn, won't make a lick of a difference on interstate commerce. What happens if there were 100 Mr. Filburns, right? And they were all being jerks, and they were all selling their wheat under the table, right? Haley, say if there were 1,000 Mr. Filburns, 100 in every state, let's say, right? How would that affect interstate commerce?
Well, I think that it
abundance of wheat that we didn't.
Exactly. Let me ask you this question. If everyone's growing their own wheat, will farmers have to buy it on the market? Yes. What? You said it.
No one would sell it, they just keep it out.
Okay, and here's the issue. This is called the aggregation principle. Aggregation principle. What does aggregation mean? You already said it. So say it again. You said it already.
Just add it up.
Yes, you add it up, right? Maybe one farmer by himself won't make much of a deal, but if every single farmer in the United States began growing local wheat, they wouldn't need to buy it on the interstate market, and that would impact supply and demand, right? So we have two questions, right? Is there substantial effect in interstate commerce? And in order to determine if the effect is substantial, we ask, in the aggregate, will these activities impact the markets? And what does, Chloe, what does the court say here? In the aggregate, would a bunch of farmers growing local wheat affect supply and demand?
Yes.
How come? I'm sorry, I can't hear you.
Well, it would, well, like Sam said, it would decrease the amounts in the market and negatively impact the price of wheat.
Good. Yes. Yes. Why would it negatively impact the price of wheat? That's exactly correct.
Because supply and demand, like.
What happens when you increase the supply? What happens to price? Price goes, yeah, supply and demand, right? When the supply goes up, prices go down. Congress, with this law, was trying to inflate prices. If you have all these farmers growing their local wheat, and they all stop buying wheat on the market because they're growing it locally, right? That impacts supply and demand. Therefore, the court holds, one farmer, Mr. Filburn, growing his own wheat in Ohio, has a substantial effect on interstate commerce. All right, everyone see that? Everyone see how that case works, what they did here, right? Okay. So, Ian, I'm going to ask you a question. Oh, I'm sorry, go ahead. The reason why it's substantial is because in the aggregate, if all these farmers start growing their own wheat, it would impact supply and demand. So it's not just one farmer. It's not just Mr. Filburn, right? It's all the farmers. If they all joined together and grew local wheat, it could impact the interstate markets. That make sense? Mm-hmm. Everyone see that? So Ian, let me ask you a question that I'll be asking the rest of this class. What's the limit here? What's the limit? If one person doing something or not doing something can impact the nationwide market, won't everything be substantial? How can you not have a substantial effect when you can aggregate all these fictional farmers growing their local wheat, even though there's no evidence it's actually happened? Okay, good. So this is an opinion by Justice Jackson, who we've discussed at length. He was the author of the Steel Seizure case. He was a prosecutor at Nuremberg. He was a New Deal lawyer. Very, very brilliant guy, right? Connor, what does Jackson see as the only limit on the commerce power? Does he see any judicial limit on the commerce power?
I don't think so.
So what is the only limit on the commerce power for Justice Jackson?
Basically, what the Congress determines is appropriate.
The political process, right? Jackson says it very clear at the end, the very last paragraph of his opinion, right? This is left to Congress. These conflicts don't lend themselves to judicial determination. We have nothing to do here. This is for Congress to decide. Jackson's like, hands off. If this is a law that passes through Congress and the president signs it, this is not for the court to second guess. Everyone see that? Jacob, what's the impact then of this decision on federalism? How does this decision, giving Congress such a broad power over agriculture and everything local, impact the states? Exactly. and this is the point we addressed last class, as the size of the federal power expands, the scope of state police power shrinks. When Congress can do more stuff, the state's police power contracts, right? Christian, Christian, we discussed this last week. What do I mean when I say the state's police power? What does that mean? Police power. What's the state's police power? Okay, that's fine. Karishma, do you remember what the police power was? Jacob, want to try it? Yes, so the police power, it's three things, right? Health, safety, and morals. And maybe welfare, depending who you ask. But the power of the states to regulate the health, safety, and welfare of their people. What states set agricultural policies, right? Let's see, I'll go back to you, Christian. Christian, what happens if Ohio said, you know what? We don't have enough wheat, and our people are hungry. This is during the Great Depression. We want to have more wheat for our people in Ohio to eat and be nourished and become Buckeyes, win championships, right? How do we, what's Ohio's answer now? If the federal government says, no, Ohio farmer, you got to stop planting. What's the answer now? And what if the federal government says, no, we need one nationwide food policy. It doesn't matter if people are hungry in Ohio. Screw Ohio. Bunch of Wolverine fans in Washington, right? They don't care. What happens then? What are the states supposed to do? Oh, they're definitely built in, but are they working here? Why not? What check and balance failed to allow this to happen? Christian, what do you think? What check and balance failed? We've discussed a number in this class. What check and balance failed to allow Wickard to happen? I'm sorry, louder? Oh, okay. Do you have an answer? What powers does Congress have? We discussed this the very first day of class. Which powers does Congress have? I can't hear you. Krishna? Which specifically? Maurice? What is the first word of Article 1, Section 1? Go. I'm sorry. Well, not just any laws. What powers are granted, Maurice? Article 1, Section 1. Go to page 17, right there. Very first 5 words. Yeah, stop there, right? What does it mean for powers to be here and granted? What's significant to those words? Enumerated. Exactly. What does enumerated powers mean? Listed. And where are those powers listed? In the Constitution, right? So the Constitution lists in Article 1, Section 8 about 20 powers that Congress can do, right? They're listed. One of them is interstate commerce, right? We know Congress has the power to regulate commerce between the states. But what happens, Brandon, when that Commerce Clause is read really broad to give Congress basically a police power? What happens then to state autonomy? Exactly, right? States have a police power. They can do more or less whatever they damn well please within certain limits of the Constitution. The federal government does not have a police power. They cannot do whatever they want to promote welfare. All they can do are those powers here and granted in this book, right? But when the Supreme Court says, you know what, we'll let Congress decide what their powers are, that check and balance, which was built into the Constitution, drops off, right? So one of the checks, which is prevent a federal police power, disappears. And with that, now the states are no longer qualified to manage their own agricultural policy, drug policy, labor policies, or Jim Crow laws, which leads us to the next case. So herein lies, I like that segue, right? Build suspense up. So herein lies the issue, right? You may say, wait a minute, Wickard is such a wrong case. This case can't possibly be right. You know, how is it that if Congress can regulate wheat that never crosses state lines, the Commerce Clause means anything, right? I'm sure some of you may think that now. But then you have to take yourselves to the next case, Hearts of Atlanta Motel, where you had businesses that were in one state, like a hotel or a restaurant. The hotel never picked up its foundation and crossed the state line, right? And that hotel didn't want to serve black customers. So what do? Right? You're Congress. It's 1964. You see that there's widespread discrimination and segregation throughout the country. What do? Do you say, okay, you know what? Let's go to this Commerce Clause thing, right? And if you say, no, this Commerce Clause doesn't support such laws, then how do you explain the Civil Rights Act of 1964? Right? This is an important question, not just for doctrine, but for understanding how laws sometimes adapt to very changed circumstances. So let's, for a moment, let's talk about the facts of Hearts of Atlanta Motel. And I have a number of pictures of the Hearts of Atlanta Motel. Okay, so this is a hotel that was in Atlanta, Georgia. Look at it. It's actually, it's really swanky too. Not everyone's allowed to attend, but it looks like a very nice hotel. And it's actually today, it's a Hilton. So the building's still in downtown Atlanta. There's the owner of the motel beaming with pride. I love this picture because they actually have motorboats in the swimming pool. I'm not quite sure where they're going to go. I honestly, I don't get it, but make sure a nice photo op. Here is the exterior of the motel. It looks like a very warm place to be. And here's actually an advertisement for the hotel. I want to stress, we'll come back to this later, that they're actually advertising AAA because they often were soliciting out-of-state drivers, which would become a salient fact. So let's give a little bit of history, which you may not know. So until the mid-1960s, a significant number of accommodations in the United States were segregated. And this wasn't just in the South. Don't beat up on the South. So this book was very prominent. It was called the Negro Motors Green Book. And this was actually a guide that was published by a guy named Green of what hotels and restaurants African Americans could stop in while driving. It's a significant problem if you're driving from one place to another and no one will serve you food or anywhere to sleep, right? That's a significant problem. So this book was actually published. Say, okay, if you're in this state, in this city, here's where you go. Because very often you had a place like this in South Carolina, if you can read that, it says cabins for colored. So they actually advertise accommodations which were not very nice for where blacks could live. So the Civil Rights Act of 1964 did a lot of things. But for our purposes, I want to focus on Section 2. Okay? Section 2 of the Civil Rights Act of 1964 governed what are called public accommodations. What do I mean by public accommodations? Hotels, restaurants, theaters, and after that gets a little dicey exactly what's public, but generally places where people can come use services. Okay? The Civil Rights Act of 1964 said that you cannot discriminate on the grounds of race, color, religion, or national origin. Not gender, by the way, that came later. Okay? But you couldn't discriminate on the basis of race or religion or color. What was the constitutional basis of the Civil Rights Act of 1964? Well, if you read the court's decision, you'll think, oh, it's all about Commerce Clause. But there's another answer, right? There's another answer the court did not want to look at. and this is the 14th Amendment. Okay, so let's go to the 14th Amendment for a second. We'll get to equal protection in a second. We haven't discussed the 14th Amendment. I'm sure a lot of you have read about it at various points. So the Constitution says that we have a guaranteed equal protection, right? That no person can be denied the equal protection of the laws, right? So what's the problem, right? Why do we need a Civil Rights Act if it says right here, equal protection of the laws, right? What's the problem? Anybody know? Anybody know why the 14th Amendment doesn't stop us from discriminating? It's a very easy answer.
Federal government, not the state.
No. Come on, Brown versus Board of Education said you can't have segregated schools. Why can't we just look to the 14th Amendment and say no segregation in private businesses? What's the problem? Anybody? Anybody? What?
Private business.
Morgan, what word did I highlight here? What does the 14th Amendment control? Who's bound, Morgan, by the 14th Amendment?
All persons born and not
No. It's highlighted. Who's bound by the 14th Amendment? States. This is a very important point. The 14th Amendment only controls states. States cannot pass laws that deprive people of equal protection. States can't do it. Morgan, can private businesses discriminate under the Constitution? Yeah. So the simple answer is, under the Constitution, private individuals are not bound. Only states are bound. So, say there was a hotel, the Hartsville Atlantis Motel, that won't admit a black customer, and the customer says, hey, hotel, you're violating my constitutional rights in the 14th Amendment. Hotel says, I'm not bound by the Constitution. This may shock you, but the Constitution only applies to government. The only provision, let's see if it's trivia, anyone know this? What's the only provision in our Constitution which controls individuals? Anyone know? Anybody know? Prohibition was, right? That's right. Prohibition did control individuals, but thankfully for us, it's not part of the Constitution anymore, right? But what's the only provision in the Constitution today that binds individuals? No, that gives us rights. That controls government. Anybody know? What's the only thing that you could do that violates the Constitution? There's only one thing.
Treason.
Slavery. 13th Amendment, right? 13th Amendment, page 48. Neither slavery nor involuntary servitude shall exist within the United States. This isn't preventing the government from holding slaves. It's preventing individuals from holding slaves. So the only provision of the government, the only provision of the Constitution that controls individuals is a ban on slavery. So while you may not own a slave, you're welcome to discriminate. We'll go to the 14th Amendment much later, but I want to at least tease this idea for you right now. Right? Jim Crow, right? The Jim Crow laws that allowed segregation in the South were unconstitutional because they violated equal protection. But the Jim Crow laws went far beyond laws of the states. It created an entire legal culture bent on suppressing an entire class of people. And Congress decided, and I think this is probably a better answer, that in order to ensure that states are guaranteeing the equal protection of the laws, private businesses cannot discriminate. I'll say that again. Congress said, if we actually want to ensure equality before the law, private businesses cannot possibly discriminate. Because how do you have it? So say, fine, you desegregate your schools, but all the restaurants and lunch counters are still segregated. When Congress passed the Civil Rights Act in 1964, they looked to the Commerce Clause, but they also looked to what's called Section 5 of the 14th Amendment. Section 5 of the 14th Amendment gives Congress the powers to enforce the 14th Amendment. So Congress said like this, listen, we want to make sure that there's equal protection of the laws. In order for us to do this, we need to get rid of the segregation in private businesses. Okay? It's not a crazy argument, right? In fact, in many respects, it's probably a better argument than the Commerce Clause. But the court didn't adopt that argument. They went full in on the Commerce Clause. Why? Not exactly clear. But the court's analysis in Hearts of Atlanta was premised all on Commerce Clause. But I want you to keep in the back of your mind Section 5 of the 14th Amendment. We'll cover that in about 2 or 3 weeks. And I promise I'll come back to this. I'll explain the connection deeper, but I want you to at least make a note of this. Okay, good questions? Yes, sir.
I have a question. Often the book and then online when you do research, they refer to they call it Title II. Would that be the Commerce Clause?
No. This is Title II of the Civil Rights Act of 1964. So these big bills in Congress, right? They have different sections which are called titles. So you might have heard of Title VII. Title VII is the anti-discrimination law, like employment discrimination. Title II governs public accommodations. Other questions?
Just like Title IX for men's sports in college.
Exactly. It's a different law, but same idea, yes. All right, so we go back to Hearts of Atlanta. We go back to our hotel, right? Almost immediately after the law was enacted, a number of businesses brought constitutional challenges saying, listen, I'm a local business. I'm here in Georgia. My hotel cannot lift up its legs and cross the border to Florida. I can't do that, no matter how hard I wish and pray, right? Look, even my motorboats are connected into my pool. They can't even leave the swimming pool. You know, there's no channels of navigation in the swimming pool, right? What does the government argue? Lauren, what does the government argue about why this hotel, which can't possibly get up and walk away, is interstate commerce?
Well, they argue, they first said that 75% of guests are from out of state,
Uh-huh.
so it discouraged travel.
Ooh, good. Uh-huh.
So the government's saying that that's affecting interstate commerce, that people being discouraged from traveling from one state to another.
Okay, so I'm going to ask you a difficult question. You said that discourages interstate commerce, right? What is that?
The discriminating.
What is discrimination? Oh, okay, and let me ask a follow-up question. In the last case, right, we had wheat, right? We had a physical article of commerce. We had a thing, wheat, that could be sold on the market. Lauren, what is, in the context of the Constitution, discrimination? Is it a thing? Is it what is it? It's an action. So we're not just talking here about a good that's manufactured or a bundle of wheat. We're talking about an action, right? An action that can have an effect interstate commerce, right? Zachary, how can an action, because we've gone a long way. We've gone from boats traveling between states, right? We've gone to manufacturing goods. We've gone to local wheat. And now we have some sort of action about rejecting customers at a business based on their race. How is that interstate commerce?
Well, there are a few arguments the government uses, and they focus on the type of businesses that are in these actions, like inns, hotels, and they're saying all these places are near highways. Or people are traveling from state to state. It also thinks like just the increase of people of all races moving from state to state.
Good.
Technology kind of growing the economy, cars, and they say, well, this act by businesses discourage people from eating on the road. People from also moving into communities, or they want to, let's say, participate in a local industry or something. If there's these practices in place that prevents them from becoming part of that community and contributing to the economy, and you're saying this on a whole, like the overall evidence of Congress committees and providing to show that this is like scattered across the nation to the extent that it affects interstate commerce all the way.
Okay, that's exactly right. Okay, Congress made all these findings, right? All these determinations that when you have when you have these businesses that segregate and don't allow customers, right? This impacts interstate commerce, right? How? Because people traveling, you know, African Americans traveling across state lines want to have a place to stay. They want to have a place to eat, right? And this frustrates the channels of commerce. But the court here does something very subtle, right? They're not saying that this business by itself is impacting interstate commerce. It's that potential customers that may come to him but are not served. That is the disruption. So you see the shift, right? This is not about making wheat or some sort of manufactured good. It's the fact that someone's decision to do or not do something may impact people elsewhere. Everyone get that? There was a, they didn't make a big deal about it, right? They were fairly quiet about it, but they definitely shifted it. We're not talking about anything that you do. It's your failure to accept the customer impacts other people who may cross state lines. Yes, sir.
We're using the aggregate principle again, the opposite way, right?
I think that's right. Explain.
Well, just in the other case you were saying as the farmer does his actions or whatever, if all the farmers all do it.
Yes.
In this case, you're saying if they don't do it, then all the actions that are not done as a whole.
Yeah, I think that's a good way of looking at it, right? So with Wickard, it's right. If there were 100 farmer Filburns, they were all growing the local wheat, it would impact the market. Here, right? If there are all these African American customers coming to this hotel, right, and they're not getting serviced, that would have a substantial effect in interstate commerce. So even if one customer shows up and doesn't get served, right, maybe that's not substantial. But in theory, if we aggregate them all together, that becomes a substantial effect.
By shifting the light off the motel and onto the individuals traveling, isn't that broadening the commerce power to allow regulation of people?
Oh, yes. Explain. You're right. But why is that regulation of people?
Because the people are the ones that are partaking in the quote-unquote commerce.
Oh.
By not allowing them to participate at the motel.
Okay, so your question is exactly right on target. I want to give you a preview of your assignment for next week, which is the Obamacare case, right? An FIB versus Sibelius. In that case, the government argued that the failure of a person to buy health insurance is commercial activity. I said it again. You'll read this case next week. No, not taking spas. The government argued that if you fail to buy insurance, you sit on your butt and you don't buy insurance, right? You are engaged in interstate commerce. So this isn't just these theoretical, travelers in the road going through Atlanta, right? This is arguing that if you never buy health insurance, you are engaging in interstate commerce. 5 justices of the Supreme Court rejected that argument, saying that inactivity cannot be regulated by the Commerce Clause. We'll get to the rest of the decision, but 5 justices agreed you cannot regulate inactivity. So your point is very astute. It's very astute because here we're not talking about wheat or manufactured goods. It's the people themselves that is the commerce.
So it's like the wheat case, if inactivity isn't like okay, whatever, what if the farmers had decided not to grow the wheat or wouldn't grow as much wheat as they were supposed to by that?
Well, okay, so then let me flip your question a little bit. What if the law said that they're required to grow 100 bushels of wheat? And the farmer says, nah, I don't feel like it, I'm lazy, right? Could Congress mandate that someone actually grow wheat? I think there might be some slavery issues there. No, I'm not being facetious. I think an actual mandate for someone to grow wheat would probably be involuntary servitude.
But like the argument would be like we need the wheat, it's affecting.
So could Congress conscript people? Could Congress say to all of you, like Mao, right? Go to the farms and start, go to the gulag, start growing wheat. If Congress does, I think we have some serious problems. Some people may agree that that's constitutional. I would part company there. I think that would probably be a 13th Amendment violation if you're forcing someone. Jason?
What about in the time of war? Could they militarize people and essentially draft people into service?
Oh, so the draft, which we will discuss when we talk about slavery, is a very close issue, right? The Supreme Court has held that the draft is not a form of slavery, or whatever, but we do have a long history of conscription during time of military service. We don't have a long history of making people grow wheat.
I mean, but could could the government theoretically conscript people to grow wheat?
What did Harry Truman try to do during the war?
You're right.
He tried to put the steel mill under federal supervision.
Yeah, you're right. Yeah, I understand.
I feel like usually whenever we have this problem, all the government does is like incentivize people. It's like, all right, we need wheat farmers, we're going to give you this farm, grow some wheat, and usually people actually do it. So I don't think we would ever really get to that issue.
All right.
Because I feel like, I don't know if exactly we've dealt with it, but I feel like there's been instances where the government needs people to do something, and so they'll usually give them incentives.
Well, there's carrots and there's sticks, right? So with Obamacare, which is again we'll discuss next week, there are carrots and sticks. If you want to buy health insurance, they'll give you all these subsidies, right? And if you don't want to buy health insurance, they'll make you pay a penalty, which I'm sure many of you may be paying in the next couple months. Right? This is going to hit millions of Americans who chose not to buy health insurance this year. They're required to pay a penalty under Obamacare.
But I've seen the Obamacare, and I'm sure we'll talk, like I mentioned the takings clause, I've seen some cases attack it on the takings clause, saying that the government can't force you to pay another private entity, which by forcing you to buy insurance, I've seen that.
Well, yeah, the takings clause isn't, we can talk after class, but it's not really on point. Yeah.
But the way you would distinguish what this Atlanta case and the Obamacare case is civil rights is a right under the Constitution, 14th Amendment. Insurance isn't a right.
Okay, well, that's the argument I was alluding to before, right? Yeah. When Congress was passing the Civil Rights Act, they looked at the Commerce Clause and the 14th Amendment, right? The Supreme Court did not want to touch the 14th Amendment here. I think the reason why is they probably have to overturn a lot of other precedents to get there. So they said, let's leave the 14th Amendment, let's just make the Commerce Clause bigger. But there's actually, as you note, a principal distinction between expanding commerce for the insurance and making sure that blacks can be seated at the same lunch counter as others. I saw a couple other hands. Yes?
Didn't you justify the Obamacare Act as like perfect price discrimination? So they want to make sure like every customer, so some wouldn't normally buy it, but maybe they can afford like $100, so they, by mandating and make sure they get that $100 or you pay a penalty. So in that case, like you're creating maximum profits for corporations that operate in the interstate. So like one person not buying insurance like doesn't really impact, but if everyone doesn't buy insurance, then like that impacts interstate commerce. So, and then the other thing is like I think if you're too poor, you don't have to.
Yes, you're right, and you're right. This is basically the argument. Sarah just articulated the argument very, very lucidly what the government argues in the Obamacare case, and we will discuss that next week, I promise. Okay? Yes.
This is a question back to Barbara Leo. You said the main point is that I guess your failure to accept the customer affects other people, in turn affecting interstate commerce.
Yes. So effectively, this is a hotel that caters to a lot of out-of-state customers, right? And because they're not accepting black customers, they're interfering with interstate commerce. That you have someone coming from North Carolina or Florida or wherever, they're traveling through the state, and they're not getting accommodations, right? That is a blockage of interstate commerce. It frustrates interstate commerce. The court also says it doesn't matter if this hotel is local character, because if there's even a slight pinch, right, a slight squeeze on the interstate market, Congress can regulate it. Everyone see that? So any questions on Hearts of Atlanta? So, and the name of the case is perfect, so you never forget what it is. Hearts of Atlanta Motel versus United States. All right. There was a companion case, right? Does anyone know what a companion case is? What's a companion case? Anyone know? So very often the Supreme Court will take two cases in the same issue. So what do they do here? They took a hotel and they took a restaurant, right? Because arguably the hotel caters to out-of-state customers, right? If you live in Georgia, you'll live in your house. You're not going to go to a hotel. Most of the people who stay in hotels are from somewhere else. Restaurants, though, usually aren't the same. So we had Ollie's Barbecue, which was in Birmingham, Alabama. And this was a barbecue. This is an actual shop. This is Ollie McClung, who was the owner of the shop, and he would not admit black customers. Interestingly, he had black waiters, which is an interesting quirk, but he would not serve any black customers. This was the barbecue, and I'm going to show you something cool in a second. So, see right here the logo for Ollie's Barbecue? I actually tracked this down. I have an entire case of Ollie's barbecue sauce from Birmingham. Okay? No, you can't open it. And I've never actually tried it. I don't even like barbecue sauce, but I have an entire case of it. I have an entire shelf, if you ever want to look, through like constitutional knickknacks, right? I got a lot of them. I'll show you another one in about a minute. Okay? So what was the issue with Ollie's, right? This was a barbecue joint, wholly intrastate, right? There was really not much evidence it ever served any customers outside the state. It was the middle of nowhere, Alabama, right? So Jonathan, what's the argument then? How is Ollie's Barbecue something that Congress can regulate? They never serve patrons from out of state.
They say it deters professional as well as skilled people from moving into areas.
Why?
Because they would go somewhere where they wouldn't serve black people.
Good, okay. What else though? Gabriel, what other argument does the court make to explain why this barbecue can be regulated by Congress? That's the other argument they make. It's a fairly short blurb they give you in your book. Let me ask you, Gabriel. Where do you think this barbecue sauce came from? What about the ingredients for the barbecue sauce?
Across state line.
One at a time. What? Where do you think all the ingredients were manufactured for this barbecue sauce? We got water, we have vinegar, we have tomatoes. Out of state, right? So what does the court say? Even if the restaurant is entirely in state, some of the ingredients they buy are from out of state, right? They want potatoes, get from Idaho, right? Some oranges, get from Florida. So the mere fact that they're serving state which moves in interstate commerce is evidence, right? Now, Emily, is there any proof in the case that they use any goods from out of state? Okay, so there's absolutely no, there's my stack of barbecue sauces. So there's absolutely no evidence anywhere in the record that Ollie's Barbecue engaged in interstate commerce. I have that evidence. Okay, this is how obsessive I am. I have proof that Ollie's Barbecue sauce in Birmingham, Alabama engaged in interstate commerce. What's my proof? This is a matchbook from Ollie's Barbecue sauce from 1963, right? I blew it up here. Where was the matchbook made? You want to read what that says? Atlanta. This was from the Universal Matchbook Company, Atlanta, Georgia. The barbecue was in Alabama. Proof in my hands that they had stuff from out of state. I have resolved the case once and for all. I was so excited when I found this, you have no idea. I actually have eBay alerts for things like this. You find the coolest stuff. I will talk. I have more stuff later I'll show you, but you find the coolest stuff this way. Anyway, so Read and Weep, Birmingham, Alabama, Ollie's Barbecue sauce with a matchbook made in Atlanta. So there we have proof that this good traveled in interstate commerce. Anyway, and in case you want to know, they have a Bible verse from Chronicles, and maybe if any of you are familiar with Scripture, you can tell me what you think about this one. Anyway, so yes, sir. Local, right? Yeah, it's like hipster stuff, right? Local grown, local source. You know, well, ask me that question in 15 minutes when we do the Gonzales v. Raich case, okay? 20 minutes maybe. I promise I'll get there. But the mere fact, Emily, I'll come back to you. Emily, what do we make of the fact, though, that anyone who buys ingredients from out of state is interstate commerce? What does this do to the limits of the Commerce Clause? that if you buy anything that may have traveled out of state, you are now engaging interstate commerce. What's the effect of that? Is it possible, and I take Maurice's question as a hypothetical, but is it possible to have a totally locally owned business where nothing you own or sell comes from out of state? Is that even possible? It's really tough. Think about it. Napkins, forks, right? Your appliances in your kitchen, right? Maybe your waiters travel from out of state. Go to any business, any restaurant, and I'll take Maurice's question as a serious one, right? Try and make a business where none of your stuff comes from out of state. None of it. I think you probably find it's impossible. Ovens, microwaves, sinks, whatever. I'll give you another example. So the state of Montana has tried to build something called a Liberty Gun. George, what do you think the Liberty Gun is, if you have to guess? Try and guess what this is. Anyone, what do you think the Liberty Gun is? Anyone know what this is?
It sounds like it would be a gun that was being made
Yes.
of component parts within Wyoming.
Yes. Yeah. Is it Wyoming or Montana? Right. I think it's Montana. Right. So a bunch of people in Montana have actually said we are building something called Liberty Guns. These are built wholly within the state. We mine the ore. We chop down the wood. We make the lead casings here. Right. Everything is local. George, can Congress regulate that?
But unless they sell it to like
No
another.
no one's selling it. They're simply manufacturing them. Does the mere fact that you have a gun impact interstate commerce?
They use the farmers thing where they have guns and not buying guns in other places and stuff like that. They go down like that.
That's the question, right? Does the mere fact that you have a gun impact interstate commerce, James? How? Where do we get this from? Okay. What about Lopez?
Lopez.
Ah. All right, and this is the segue to Lopez, right? Does the mere fact that you have a gun, and there's no proof this gun ever traveled in interstate commerce, you have a Liberty Gun, right? Does this make you engage in interstate commerce? So this brings us to the Lopez case. By the way, here's the advertising for the Universal Match Corporation in Atlanta. I found that also online somewhere. Anyway, set the world on fire. Oh, my heart. Anyway, so anyone know where Edison High School is in San Antonio? Yeah, you know what it is? Do you go there? Why no? Okay. Anyway, so I was kind of hoping someone would say that. It's better him than me, right? So we have Edison High School in San Antonio. Okay, this is actually a photograph of the gym of the high school. Here we have Mr. Alfonso Lopez. I apologize for the blurry picture. That's the best one I could find of him. I've tried looking for a mugshot. I can't find it because he was a minor. There it is. Alfonso Lopez. You can kind of make it out. There he is playing soccer. I had randomly someone send me these pictures who went to the high school. I didn't know who this person was out of the blue because I blogged about it. I was like, hey, I went to high school with this guy. You want a picture of his yearbook? I'm like, all right, whatever. So this I told you, I have a lot of this stuff. Anyway, so here he is playing soccer. Rushing down the field, Alfonso Lopez warms up before the game. Okay? So we have Lopez, right? Now, as I'm sure many of you are aware, virtually every state, Texas included, has a law which prohibits bringing a gun into a school zone. And I'll pause for a second. When they say school zone, they don't mean just the school. They mean the school plus a 1,000-mile radius. That's a fairly large radius. And I want to put this thought in your head for a moment. Whenever you see a law,
You mean like 1,000-foot radius or 1,000-yard radius?
1,000-foot radius. 1,000-foot radius. Well, I was on my next point, right? So I wanted to put something in your mind. You often see laws passed say you cannot have a gun within 1,000 feet of a school. You can have drugs within 1,000 feet of a school or a park or a playground or whatever, right? In most urban environments, it's very hard not to be within 1,000 feet of a school, park, or playground.
Yeah, I was gonna ask.
What happened?
If you live across the
Oh, isn't that something, right? Let me give you a story. So when I was clerking, I had this one case involving a drug offense, right? And this guy lived in a housing project, right? And the housing projects, there was a playground. And I think you see virtually every housing project has some sort of playground, a park, or something, right? The prosecutor said, wait a minute, he was dealing drugs within 1,000 feet of a park. It was his apartment. He lived in an apartment in a housing project which had a playground. This is a dirty secret of prosecutors. They can always amp up charge for saying, oh, he did it near a park. So to your question, you're right. If you live across the street from a school, you actually can't own a gun. It's actually this weird rub, unless the legislature exempts home ownership, but carrying it, even if you have a concealed carry license, is basically illegal. This is a big problem with sex offenders. Now, we can talk about sex offender registry as another part of class, but you have people in Miami who can't live within, say, 3,000 feet of a park, school, church, whatever. They have nowhere to live. There is nowhere in the city they can live, so you live under the highway, underpasses in Miami. While you can't prohibit stuff, government's like saying, oh, you can't do within 1,000 feet of anything, which basically maps out the entire city. Okay, so you'll do this in property also, land use, but be very aware whenever they say you can't do anything within 1,000 feet of a school. That's basically everywhere, right? All right, so most states, though, have these laws saying you can't bring a gun to a school zone, right? The wisdom of these laws, we don't really need to discuss. But Congress passed a federal law, the Gun-Free School Zone Act of 1990. And the Gun-Free School Zone Act says that you can't bring a firearm within 1,000 feet of a school zone. Okay? So here we have Mr. Alfonso Lopez at Edison High School. And he brought a .38 loaded with five bullets to class. Someone found out about it. They tipped off the authorities. And they arrested him. And Texas brought charges against him for bringing a gun into a school zone in violation of Texas law. But Pedro, what happened after Texas brought the charges?
He dismissed the case and then brought him to federal.
Ah, you're exactly right. The states dismissed the charges and the feds brought their federal charges. Pedro, what do you think happened here? Why do you think the feds came in here?
I think they just wanted the publicity. I mean, I can't imagine why. I mean, under state law, they probably could have had him.
Oh, they had him dead to right. He was in jail, right? Yeah. So Pedro, let me ask you this question. If you're a state prosecutor, right, what's the advantage of having the feds take over a case? You're a Texas Attorney General. Some of you may be Attorney Generals in a couple of years, right? What's the advantage, Pedro, of the states handing to the feds?
Not having bad publicity.
What's the financial cost of the state here?
Oh, it's really high.
Okay, this is an unfortunate fact of life today, and you see this a lot in the drug context. States have very short budgets. When they have to arrest Mr. Lopez and throw him in jail, states have to pay for that. It's a lot easier for the state to say to the feds, hey, you guys, go take this. I get all the credit for making the bust, but the state of Texas does have to pay for his prosecution and his incarceration. Not our problem. This happens very often in drug busts, where the states will find some huge cache of drugs or a drug deal or whatever, and they hand it off to the feds. And the feds then prosecute it. States take all the credit. They put the bad guy behind bars, but it doesn't impact the state budgets. So everyone see what's going on here. All right. So now a brief point in lawyering. This case began in 1992. Okay. So Gabriel. Gabriel, let's say for a moment that you're a public defender, and you may very well be in a couple of years. Some of you may be public defenders. So you're the public defender for Mr. Lopez. He just turned 18, so he's an age majority. He's not a minor. And they caught him dead to right. I mean, he had the gun There's no question brought the gun to the school zone, right? If you were a public defender in 1992, what do you think you would have done? I mean, they got him. He had the gun in the school zone. There's no question about it.
I would have said that perhaps, I would have said it doesn't affect.
If you were the public, and I'm asking solely honestly, if you were a public defender in 1992, would the idea of a Commerce Clause challenge even come across your mind?
I would say it falls out of the scope.
No. Would you even have the idea to challenge a criminal prosecution under the Commerce Clause?
No.
Why is the answer no?
Because it falls out of the scope.
No? Yes, what do you think? No? Elliot?
I was just gonna say that, isn't their job mostly just to like get through cases and be efficient?
Not the answers I'm looking for, but that's correct. Okay?
Well, they're looking for the common good of just that local area. Cops are, they just care about their residents and not necessarily.
No. Let me explain it like this. Amanda, what was the state of Commerce Clause law, of Commerce Clause jurisprudence after Katzenbach and parts of Atlanta? What did everyone understand the Commerce Clause to mean after those two cases in the 60s?
That they could regulate, that they have limits?
I'm sorry?
That they didn't have any limits?
Yes! After the 1960s, basically everyone in the world understood that the Commerce Clause has no limits. If you were to open up any constitutional law textbook in the 60s, in the 70s, in the 80s, under the section of the Commerce Clause, it would have stopped with parts of Atlanta and Katzenbach and said, well, you know, the court said there are these limits, but they've never identified them. So basically, any single law Congress wants to enact is constitutional. That effectively Congress has the police power, which we thought they didn't have. An entire generation of lawyers came of age with this understanding of the Constitution. Go talk to any of your parents or lawyers. They went to school in the 70s or the 80s, whatever, right? Ask them and say, you know, Mom or Dad, what do you remember about the Commerce Clause? They'll say, well, I don't know, it means whatever you want. So you are all in a different culture. You're in my class in particular, but you're being introduced to a very different constitutional law, right? If I taught this class 30 years ago, I would have stopped with Hartsville and said, all right, folks, that's it. Congress do whatever it wants. But we're going to go to Lopez, to Morrison, and to Obamacare. So I need to give credit to Jack Carter. You've never heard his name. Jack Carter was the federal public defender in San Antonio who had the genius idea to think, wait a minute, we should raise a constitutional challenge to the Gun-Free School Zone Act. I'm sure all of his colleagues said, what are you, stupid, right? Why are you wasting your time with this? You have all these cases in your docket piled high. Just let him plead guilty. You know, he'll get a slap on the wrist and go back to whatever, right? This guy had the chutzpah, right? The gumption to say, you know what? I think there are limits in the Commerce Clause. And let me tell you something else. Every single law professor in the country, save like maybe 5, laughed at him. They said that this case is ridiculous, that the Commerce Clause has been settled, that this is a done deal, the New Deal resolved this question. And then the Fifth Circuit Court of Appeals right here in New Orleans said that this law is unconstitutional. This was an oh crap moment, okay? I don't say that lightly. After this case was decided by the Fifth Circuit, right, the entire issue blew up. Every law professor in the country said, oh my God, maybe the Commerce Clause is not settled. I'll give you some more history, right? After the Fifth Circuit invalidated this law and the Supreme Court granted certiorari, they granted review of the case. Do you know what Congress did? Did anyone notice it was in a footnote? Did anyone notice this? It was in footnote 6, I think, in the decision on Lopez. Do anyone remember what they did? After the Fifth Circuit invalidated the law and the Supreme Court granted review, what did Congress do? I think it's footnote 6, right? Remember? What happened? It was in 1994. Oh, yeah, that's it. 2004. Yeah. What happened in 1994? And what did they try and do with that law? Yes! They tried to fix it. They tried to fix it. What had happened was that Congress had gotten so damn lazy. Right? Congress had gotten so lazy. They didn't even bother putting into the statute a single sentence about how banning guns impacts interstate commerce. Congress, for 30 years, had gotten so complacent, so comfortable, that they didn't even bother making a single finding about why guns in school zones impacts interstate commerce. This is because an entire generation of law students, an entire generation of lawyers had stopped learning at Katzenbach and said, yeah, that's it. Congress can do whatever they want. Don't even bother making any findings. So what did President Clinton try to do? They passed a new law, the exact same law, with some findings about its constitutionality. Everyone see that? So the problem here was that basically everyone assumed that this was a done deal until one enterprising public defender in San Antonio, could be any of you in a couple of years, right? Remember this ConLaw class, right? I don't know where he went to law school. I actually emailed him, never replied. But I don't blame him, right? I emailed him about 4 or 5 years ago. He never got back to me. I tried. I said, thank you for what you've done, right? But a single public defender remembered something in ConLaw about the Commerce Clause, maybe a gun that's locally owned that's never traveled in commerce isn't something Congress can regulate? Challenge the conviction, don't plea out. Yes, ma'am. This, Lopez. That's the case we're talking about. He was a federal public defender in San Antonio. Yes, ma'am. No, they do not have the police power. Congress never has a police power. They can only do that which is given to them by the Constitution. So and we'll do the holding of Lopez in a few minutes, right? But Congress can't simply assume they have the power to act. They need to show how this law has an impact on interstate commerce. How do guns in schools impact interstate commerce? Everyone see the issues, right? So Lopez is a very good review. And if you want to know the history of the Commerce Clause, reread Lopez. Chief Justice Rehnquist's opinion does a very, very effective job at summarizing all the precedents. This is much better than any horn book you'll read from the Supreme Court also, but he does a very good job of summarizing all of these principles. Okay, so any questions before I get started with the case? The history of this case is fascinating. Anything? Okay. Maybe one day he'll reply to my email. I don't think he will. I forgot. I tracked his email down there and asked. So you get creative. So Chief Justice Rehnquist begins his opinion with a very, very important sentence. We start with first principles. Alana, what does that mean? We start with first principles. What's the significance of Rehnquist's opinion beginning with that phrase? Yeah, what do you mean history?
The history
of what law? Good. We start with the history of the Constitution. Right? He doesn't start by looking at the New Deal or the 1960s. Rehnquist begins by looking at what he calls first principles. He looks to Federalist number 45, Madison, who explains that the powers of the federal government are limited, few and defined. But the powers of the states are numerous and indefinite. Madison writes, the reason why these powers divided is to ensure the protection of liberty. Right? that the reason why the federal government has limited powers is because it's meant to preserve liberties and promote state autonomy. That this doctrine of enumerated powers, quote, reduces the risk of tyranny. That the separation of powers reduces the risk of tyranny. To use a phrase which I repeat far too often, ambition must be made to counteract ambition. Allowing the states to have their own sphere of power checks federal authority. Okay? So, as a matter of first principles, what we might call originalism, we're trying to understand how would the framers have understood the phrase commerce? How would the framers have understood the meaning of regulated interstate commerce? As a matter of first principles, most of the 20th century is unconstitutional. There's not much other way of addressing that, right? Renee, what does Justice Thomas say in his concurring opinion? What's Justice Thomas's position? Do you have it? Jennifer, what does Justice Thomas say in his concurring opinion? The original understanding of the Commerce Clause.
That it's much more narrow than it is today.
Okay, so Thomas goes through a fairly detailed, what we might call originalist analysis, where he tries to understand how would the framing generation in the 18th century have understood interstate commerce. And Jennifer, I'll ask a follow-up. Does Thomas think that the precedents for the New Deal in the 1930s and 40s are consistent with how the framers understood commerce?
No, sir.
Why not?
Because they're giving Congress too much power.
Okay, so Thomas makes a point, and as a matter of history, no one really argues with him. I think he's probably correct historically. As a matter of originalism, the 20th century is probably unconstitutional. That's one of my punchlines in my book talks. Like Justice Thomas says the 20th century is unconstitutional. Well, yes, but what do we do about stare decisis? Right, Megan? Stare decisis means we stand by precedent. We rely on precedent because people become expecting of certain principles. What's a justice to do when he says that the last 100 years of case law are wrong? How do we reconcile the original meaning of the Constitution and precedent? Okay, very good. So here we have a dispute, right? On the one hand, we have Justice Thomas, the originalist, who says, listen, here's what the Constitution says. Its meaning is fairly clear. All these cases are wrong. And then we have someone like Justice Kennedy, in his concurring opinion, says, well, you know what? Precedent is important. Stare decisis is important. People rely on these cases. We built an entire administrative state on the idea that Congress can regulate just about anything, right? So what the court does is very interesting, right? The majority doesn't go as far as Thomas does in overturning, 90 years of precedent. They don't go quite that far. But what they do can be summarized in one sentence. Ready? This far, but no further. This far, but no further. The compromise the Chief Justice makes to keep a 5-vote block is he says, listen, we have these New Deal precedents. We accept it. Fine. But we won't go any further. We're not going to get rid of Darby and Wickard and Hearts of Atlanta. We'll keep those. But if Congress asks us to go beyond that, then we can judge it anew. That doesn't mean they're acting unconstitutionally. But if they want us to go further, it's a new question. We're not bound by stare decisis. And Rehnquist says it very specifically. We will not go further. Everyone understand that? It's a very subtle point which virtually everyone missed after Lopez was decided. And hint, preview, this is how Obamacare was decided also. Right? That the Obamacare law was not covered by the New Deal settlement. Obamacare was not covered by the New Deal, was not governed by Wickard, therefore it's not controlled by the New Deal. This far, but no farther. Okay? So any questions on that? So Rehnquist's analysis is very helpful because he provides a very good summary of the case law. Okay? And he identifies 3 categories of commerce that Congress can regulate. Yes, sir.
When you say E, who are you referring to?
Justice Rehnquist. Chief Justice Rehnquist. If you ever called him Justice Rehnquist, he would yell at you from the bench. He's like, "I'm Chief Justice." It was actually a very big deal because sometimes people. Well, the other one was people will call Justice Ginsburg Justice O'Connor and vice versa, and they apparently don't like that very much. And if someone ever called him Judge Rehnquist, that was even worse. It's Chief Justice Rehnquist. Chief Justice Rehnquist got a little loony later in life, where he saw an opera where one of the characters was a judge, had these golden stripes on his sleeves. So he had gold stripes put on his sleeves at the court. He was an odd duck, but his opinion is very good. Very not as good, but it's very clear. So he identifies 3 categories of commercial activities. And then the way I remember this is CIA. You can remember the acronym CIA. First, channels of interstate commerce. First, the channels of interstate commerce. Second, I, instrumentalities of interstate commerce. The instrumentalities of interstate commerce. And third, activities with a substantial effect on interstate commerce. Activities with substantial effect on interstate commerce. Okay? CIA, remember it that way, easy enough. All right. What are these, Mary, what are these channels of interstate commerce? What does that mean? What are channels of interstate commerce? Which cases fall under that line of reasoning? How does Heart of Atlanta fall under the channels of interstate commerce? Yes, right? So if it actually involves people traveling through various states, those are what are known as the channels or pathways, if you will, of interstate commerce. Job, what about these instrumentalities? What the heck's an instrumentality of interstate commerce?
It'd be the things that get you across the state.
Yes. Trains, for example, right? Trains. So we discussed the Shreveport rate case. Rate, R-A-T-E. The Shreveport rate case. Even though the train is only in one state, it choo-choo-choos and it can go across state lines. So it's an instrumentality. Okay? So what Rehnquist did in these first 2 categories was he tried to summarize a lot of cases that didn't really make sense before. But he grouped them together in a way that actually, maybe works, maybe it doesn't, but it makes sense. The 3rd category is the key. Activities that have a substantial effect in interstate commerce. Okay? If the action in question falls beyond these 3 categories, it's unconstitutional. The court makes very clear that Congress does not have a general police power. They can only regulate commerce in these 3 specific categories. So if something falls outside, it doesn't work. A very common form of argumentation in the Supreme Court is like a slippery slope, and it goes like this. If Congress can do this, then they can do that, right? If Congress can do this, they can make you eat broccoli or whatever else the argument goes. Okay? Yes, sir.
You said if it falls outside of these 3.
It's not a regulation of commerce, and Congress cannot do it. Thank you. So here's the question, right? Does the Gun-Free School Zone Act have a substantial effect on interstate commerce? So Crystal, let me ask you this question. Based on Hearts of Atlanta, and Katzenbach, don't even read this case, right? Would having a gun in a school impact interstate commerce based only on Hearts of Atlanta and Katzenbach? I'm sorry, louder?
Yes,
How so?
because, a gun is not,
Good. So Crystal said the materials for a gun come from out of state. I don't think there's a Liberty gun. Actually, I think it was a Smith & Wesson, but I'm not sure. It probably wasn't manufactured in Texas. The bullets probably weren't manufactured in Texas. At some point, that gun probably crossed state lines. But Hector, beyond the merely fact the gun crossed state lines, what's the reason why Congress may want to prevent guns from coming to school zones? Why is that something Congress would worry about?
Well, according to what the case says, or you're saying?
I'm asking you based on Hart's Atlanta and Katzenbach.
I don't know, maybe it might deter people from wanting to travel to Texas.
Yes, right? Hearts of Atlanta says these bans on serving black customers in hotels may impact people traveling across state lines. They may not want to come to Georgia. If we know that all these schools in Texas have these kids running with guns, maybe people won't want to travel to Texas, or they won't want to study in Texas schools, right? Yes, ma'am.
Texas had its own law. So
Oh, what if Texas didn't have the law?
well, then it might have been another question, I guess, for another state.
So there were only, I think the book said 40-something states had these laws, which means about 10 didn't.
Right.
So what if the case is brought at a school in a state that didn't have this law?
Well, I would still feel like even though the stuff is taken from state to state, it doesn't affect the commerce. I don't.
We'll get there in a second. We'll get there in a second. But I want to say, under Katzenbach and Hearts of Atlanta, the gun traveled interstate commerce, and guns in school can impact education and travel, right? Connie, why doesn't the government win easy 1, 2, 3? Why is this not a simple, straightforward application of Katzenbach and Hearts of Atlanta? It seems so simple, straightforward. What changed?
Is it the idealistic of we're not just going to allow anything to be defined as commerce, like people, like we were talking about early, people and their actions, and the slope that it went from, just the intermingling with the states to how you act for discrimination, and this is the gun law, and now we can't say that this is now commerce.
Mm-hmm. Did you end up? Yeah.
I was gonna say, they kind of make the argument that if you apply this logic to everything, you can trace everything back to an economical viewpoint or something. And so therefore everything can be controlled.
No limit.
Exactly.
I was gonna say, it's whether or not it substantially affects.
Mm-hmm. Okay, so I think what Ovi said is correct, right? Under a faithful reading of Katzenbach and Hearts of Atlanta, the government wins this case. Right? The government wins this case under a faithful reading. But what the court does is they draw a line in the sand. And they say, listen, these cases left open an issue which we're now narrowing. Right? What is the limit? If we take the argument that any gun that involves parts made out of states' interstate commerce, Congress gets a police power. If we take the argument, as the dissent makes, that if there are guns in schools, it might impact travel and education, no limit. Congress has a general police power. Because Congress cannot have a general police power, this law cannot be constitutional. Specifically because Congress failed to make any showing, not one, about why this impacts interstate commerce. They got lazy and complacent. They didn't make any showing. Okay? So there are a number of lessons that we can learn from this case, right? The one I said before. Rehnquist said, this far but no further. We're not going to reverse these New Deal cases, but we're not going to expand upon them. We're going to draw a line in the sand and say, we can't have this unlimited police power. There has to be a limit. And here the limit, there must be some economic activity. The mere possession of a gun by itself is not economic activity. Merely owning a gun, having a gun by itself, that is not economic activity. Who wants to do that? Connie, what would have happened if Congress had passed a law that included one sentence saying the Congress finds that guns in school zones impact education and that frustrates interstate commerce? If Congress had added that one sentence to the bill, would the law have been saved?
Yes,
Why?
because they would have included they would have complied with what the Constitution said, that is
Yes.
how a law is formed.
Yes. This is what we call a jurisdictional hook. A jurisdictional hook. Think of like, you have a little hook that catches onto a fish. They need to hook somehow this law to the Constitution. And if it added one sentence, right, explaining why gun ownership impacts interstate commerce, arguably, the law would have been upheld.
Does it matter if it's like a bogus reason?
Oh. So what happens if Congress makes up some dumb stuff?
I thought their argument didn't. Like,
Does it matter if the argument's bogus?
I would think so, but I'm not sure.
Anyone? Yeah.
Rational basis test.
We're not there quite yet, but that's the right answer. Generally speaking, you're right, but we're not discussing rational basis yet. Generally speaking, the government will defer to the findings of Congress. So if Congress makes a finding that, having too much wheat impacts surpluses, okay, whether there's a matter of economics that's true or not, it doesn't matter. If Congress finds it, that's good enough for us. Okay? Because look at the dissent by Justice Breyer, right? Justice Breyer says, we have all these statistics and literature saying that guns in schools impact education. Teachers can't study. Kids are getting killed. There's all these terrible things that happen. Had Congress issued Justice Breyer's dissent as a finding, the law would have probably survived. So Lopez says, if you have this non-economic activity, owning a gun is not economic activity, Congress cannot regulate it. Okay? This case sent shockwaves that reverberated throughout the legal establishment because no one expected this to happen. This basically shifted 40 years of constitutional law. Every ConLaw book in the country has to be reprinted. You think this is nothing new. It's a 20-year-old case, but this was a very big deal. Okay. Vicky, one last point. How does the majority respond to Justice Breyer's arguments, right? Why can't we simply say, well, if there are guns in schools, kids can't learn, and if kids can't learn, they won't get good jobs, and if they don't get good jobs, it'll impact commerce. How do we respond to that?
Well, they responded by saying, I think, by asking how far removed can this action before you have a causal change to how it's going to affect other states.
Yeah, so the way the court explains it is that we're not going to pile inference upon inference upon inference, right? If this happens and this happens, if this happens and this happens, if this happens and this happens, right? If you make this chain long enough, you can justify anything. The court says we will not pile inference upon inference. Quote, we decline here to proceed any further. Okay, any questions on that? Any questions on Lopez? This case unsettled law. I know the majority made it seem like, oh, we're not changing anything, but they definitely shifted law. Good or bad, we can discuss, but this was definitely a significant change in our federalism jurisprudence. Okay? All right, in our remaining time, I want to discuss two cases that are mentioned in the notes. Okay? The first case is called United States versus Morrison. Okay? This is a girl, her name was Chrissy Berzon-Kala. She was a student at Virginia Tech. And she claimed that she was sexually assaulted by a couple of football players. This stuff happens from time to time, it seems. So her assailants were Antonia Morrison and James Crawford. They were football players at Virginia Tech. So she claimed that this happened. The police in Virginia Tech in the town, they didn't prosecute. She alleged that they didn't prosecute because they were popular football players, whatever, right? So then she brings a cause of action under this new law, VAWA, the Violence Against Women Act. And this law created a way to sue in federal court for any kind of gender-motivated violence. Okay? Now, here's the behind the story that you probably don't know. Could she have sued Aleda in state court? Could she have sued her two assailants for assaulting her in state court? Was there any problem there? Okay, so she could have sued in state court, right? But when you sue, what are you trying to get usually? Money. The thing that she really wanted to sue is not these two football players, but Virginia Tech. She was trying to sue the university to try and get money from the school, saying they covered up this sexual assault, right? We discussed this before. Can you sue a state? No. Especially Virginia Tech is a state institution. She couldn't sue in state court. But this law allowed her to sue the university in federal court. That's why this case went to federal court. Virginia had perfectly good laws that allowed her to challenge what do you call it? Get money from these two guys, but it didn't allow her to sue the school. So she went to federal court under VAWA to sue the university. Okay, that's history people don't actually know. Okay. In Morrison, the Supreme Court found that this aspect of VAWA was unconstitutional. Why? Because violence against women is not economic activity. Right? This follows directly from Lopez. Just because some sort of activity affects interstate commerce doesn't make it something Congress can regulate. Violence against women, as terrible as it is not interstate activity. But more so than that, protecting against violence was traditionally an aspect of the state police power. Health, safety, welfare, right? The court says this gives the federal government effectively a federal police power. They can regulate wholly local domestic abuse. If the government's argument's accepted, Congress can regulate any crime locally. Murder, family law, anything else. And because Congress does not have the power to regulate these local crimes, this aspect of VAWA exceeds the Constitution. Lopez and Morrison are kind of the pair, right? So you had Lopez and you had Morrison, and people start freaking out, saying, oh my God, all these laws are going to be invalidated. What's going to happen next, right? But then, in 2005, the court took a step back. Okay? This is Angel Raich. Does anyone know what she's holding in her hand? Let's see who my students are. Oh, come on. What kind of pipe? Thank you, sir. It's funny. Whenever I give this talk at different states, I always get different answers. All right, let's get a better one. Who knows what this thing is? Thank you, Zachary. So I appreciate your honesty. Sometimes I give talks like, no one wants to raise their hand. Look, it's a product. It's for sale, right? So it's funny when I gave this talk at NYU once in New York. The guy's like, vape. Yeah, I'm like, yeah, that's whatever. So Zachary, do you know why she's toking? Yes. So she had a very advanced, I think it's a melanoma, or some, it wasn't cancer, but some very painful condition. And the only thing that gave her any kind of relief was medicinal marijuana. Now, she lives in California. Under California law, she had a license for medicinal marijuana. As you may know, it remains illegal under federal law to possess marijuana. Now, all of her pot was locally grown. This is hipster stuff, right? It came from local Whole Foods. I mean, it was grown not too far from her. The seeds never left the state. The puffs of smoke never crossed state lines. This was in every aspect locally grown marijuana. You have to be green, I suppose. So Raich filed a lawsuit against the Attorney General saying that you cannot regulate marijuana, right? You cannot regulate locally grown marijuana, okay? After Lopez and Morrison, people were getting very excited. Are they going to identify another limit on the Commerce Clause? Ultimately, the court did not. In a 6-3 decision by Justice Stevens, the court held that Congress can regulate this marijuana because it has substantial effect on interstate commerce. Follow me here, right? They said this is controlled by Wickard. So, Farmer Filburn grew local wheat, right? Because he grew local wheat, he didn't have to buy any marijuana. He didn't have to buy any wheat on the interstate market, right? Similarly, because Angel Raich bought all this local marijuana, she didn't need to buy marijuana in the interstate market. What interstate market? Exactly. This is why this case is so frustrating. The court effectively said, and this is Justice Scalia's decision as well, when she grows this local marijuana or buys local marijuana, she's frustrating the interstate marijuana market. What is the interstate marijuana market? It's not what you think. There's not some sort of online exchange where you can buy pot across state borders. This is the federal government's power to regulate marijuana. And this is the point Scalia makes, which I think is probably more correct. If Congress wants to prohibit marijuana, which we assume it has the power to do, they need to be able to clamp down on growing it. If you allow marijuana to be grown locally, it frustrates Congress's entire interstate enforcement mechanisms. Right? So the majority simply says, yeah, this is Wickard, right? It impacts the interstate market. Justice Scalia, his concurring opinion makes, I think, a better point of saying, listen, when you have this economic activity that frustrates a law enforcement scheme, Congress can regulate it under its necessary and proper powers, right? In order for this enforcement regime to be effective, Congress must have the power to regulate it. So we have Raich. Congress can regulate locally grown marijuana. The seeds never cross state lines. Scalia says we need to be able to regulate this because Congress can have a criminal enforcement scheme. We can't have these people growing marijuana. Okay? This case was frustrating. So this was actually argued by my good friend Randy Barnett, who was Angel Raich's lawyer. And people were actually excited that maybe the court would roll back some of these New Deal precedents. But Stevens said this is covered by Wickard. So even though you have a product that's wholly interstate, that will never cross state lines, and there is no interstate market, right? You have your wheat and you have your weed. Or I'd like to say you have your grain and you have your ganja. I've done this before. So Raich, by all extents, signaled that the court was done. People said after Raich, well, you know, we were all cool with Lopez and Morrison. That was really nice. But yeah, no more limits of federal power. But then we have Obamacare, right? We have Obamacare. And I'll give you a brief preview. We have no class on Thursday, so we'll meet again next week, right? So we have Obamacare. After Raich was decided, virtually everyone assumed that the Supreme Court was done enforcing limits on the Commerce Clause. So Congress passed a law, the Affordable Care Act of 2010. And the law said like this: you shall maintain health insurance, and if you don't, you pay a penalty. Someone asked me before, can Congress regulate persons, right? Well, Obamacare wasn't regulating a product like marijuana or a gun like in Lopez. They were actually regulating not economic activity, but the lack of activity. If you notice, all these cases said there are different classes of activities Congress can regulate. Classes of activities. What happens if Congress is not regulating class of activity, but it's inactivity? And this is the core of the constitutional challenge to Obamacare, which we will do next week. All right? Any questions? All right. Thank you very much.